Yeah, Baba, good morning.
Good morning. How are you?
Allow for the presentation. We don't normally do that. So I think, colleagues, we will be in that dimension. And of course, given the fact that there's the load shedding challenge, I really hope we'll be able to have a proper meeting. And System put Ben, I think let us finalize the application for all our meetings to now be physical.
Recording in progress.
I think this virtual world continues to be impractical for effective engagements. It's just not working. So I think that is something we need to consider and implement as a matter of priority. Right. So, colleagues, good morning and welcome. Honorable Minister will make remarks, and then Road Accident Fund, your presentation, high-level executive summary of it, of the salient points. And then Honorable Hatebe will then lead us, and we will see how far that takes us. So, colleagues, good morning and welcome. And to say I'm made to understand that our reports tomorrow will not be read as one. They will be one report. So the two reports will be read individually. So not that other previous arrangement which we have had where the reports are clustered into one. All right. Mphathiswa.
So you have 10 minutes tomorrow, une 10 minutes yakho wedwa.
Bekongangiyese kula ma report. Acishe ngasha nendlu ngenxa ya Eskom. All right. Mphathiswa wezothutho masinikeze wena ke Mhlonishwa, and then we'll proceed.
Okay, thank you, Chair of the Standing Committee on Public Accounts, Mr. Nkululeko Hlengwa, Chairperson of the Road Accident Fund, Ms. Thembelihle Msivi, Chief Executive Officer of the RAF, Mr. Collins Letswala, and the members of the Standing Committee of Public Accounts. On the 4th of November 2021, I wrote to Parliament tabling reasons for the delay in the tabling of the annual report and the audited annual financial statements of the Road Accident Fund. At the time, the audit of the RAF was not yet concluded, and I advised Parliament as such. Earlier this year, I corresponded with the Parliament providing reasons for my inability to table the annual report of the Road Accident Fund for the 2020-2021 financial year. This was a consequence of the impasse between the RAF board and the AG on the audit of that financial year. I subsequently submitted an update report which was tabled before Parliament on 30th March 2022. The Auditor General has since published the RAF audit report in terms of mandating prescripts. You will appreciate that the RAF declared a dispute with the AG and approached the courts to seek a judicial review of the findings of the AG. The review application is currently before court. As an executive authority of the RAF, I'm enjoined by law to ensure that the annual report and financial statements fairly present the state of affairs of the public entity, its business, its financial results, its performance against predetermined objectives, and its financial position as at the end of the financial year concerned. The accounting authority of the RAF contends that the dispute with the Auditor General has a material effect on its ability to meet the requirements of Section 55(2)(a) of the PFMA. This is the crux of the matter, Chair. The implications of an incorrect classification of the business of the RAF as an insurance scheme as opposed to a social benefit may have a knock-on impact on whether the report tabled before Parliament fairly presents the business and financial results of the entity. I'm under no illusion that accountability is the key tenet of our democracy, and organs of state are bound by this imperative at all times. Our approach on this matter has always been informed by this understanding. The existing fault-based system was the subject of 1998 white paper on the Road Accident Fund, and was investigated by the Satchwell Commission. In its final report, the Commission described the system as unreasonable, inequitable, unaffordable, and unsustainable. It was on the basis of the findings and recommendations of the Satchwell Commission that Cabinet approved the policy for the Road Accident Benefit Scheme on 7 September 2011, effectively replacing the 1998 white paper on RAF. This policy provides a scheme of structured and defined benefits to those seriously affected by road accidents in accordance with social insurance principles and not liability insurance principles. This is South Africa's national policy, which unambiguously requires of us to integrate the social insurance provided by the RAF into the country's overall social security system. The chairperson of RAF board, Chair, Ms. Thembelihle Msibi, will lead the RAF presentation with your permission, Chair. I will pause. Thank you.
All right, thank you very much, Minister. All right, with that background, I think let's go to the RAF colleagues, and then in the interim system, please make sure colleagues have got the correspondence, including our legal opinion that we had sought on this matter. All right, RAF, over to you.
Sorry, Chair, just to get clarity, is the representation from the Auditor General's office present and the National Treasury?
Auditor General has submitted a response, a written response. So please make sure it's dated 26 August. So please just circulate it to members quickly.
Now I'm asking, are they present today in the meeting?
To my knowledge, the AG is here today.
All right,
And
no.
Treasury, yes. So Tombi will just update on that one. Yeah. All right, RAF, over to you. RAF.
We don't say RAF asimboni.
I hope they're
Chair.
Yes, the chair says she's load shedding challenges.
Oh, okay. ESCO. All right, let's go to the CEO, and they will.
Yeah. Yes, Chair. Good morning, Chair. Good morning to all present today. The Chair, as I said, apologies. She's having connection challenges due to load shedding. I'm gonna go into the presentation, but before I do that, let me acknowledge the presence of the board members that are here. Mr. Moses Nyama, Ms. Lorraine Francois, Mr. Bosara Manzi, the chairperson of the audit committee, Mr. Hilmi Daniels, and Mr. Khotom Towi. They are all there. I think I don't see the deputy chair, but my understanding is that Ms. Nomonde Mabuya is also here. And of course, the executives that are here. It's Mr. Patulu Kwareni, Fikiswa Fikeni, Sefotle Mudiba, Mampi Kumalo, Ernest Futukiter, and we have got Mr. Tam Petrudi here as well. Just by way of prefacing this, Chair, I think one needs to be clear that where we sit as the RAF, we always want to make sure that we account properly. And I think that's what has been at the core of this dispute that we have with the Auditor General. I'm going to try to go through, Chair, the presentation as submitted. One of the first things that one should do is look at the dispute from a point of view of what is in dispute and what is in agreement. I think we agree it's common cause between us and the AG, certainly that GRAP 19 does not apply to RAF, and we'll put it clear why it doesn't apply. And we'll then go through GRAP 3, specifically 13 that talks about the change in accounting policies. When do you change an accounting policy and why you change accounting policy? And I think then go through paragraph 8 of GRAP that deals with the judgment in developing and applying an accounting policy, where there is no GRAP frame, there's no GRAP standard that applies. And of course, one of the things that we need to clarify is in terms of how we are classified by our own regulator, which is the Prudential Authority, and I think that becomes important in this. But let me say, Chair, we wanted to give, by way of background, the mandate of the entity, which is just clearly the object, which is to payment of compensation in accordance with the RAF Act for loss or damage and wrongfully caused by driving of a motor vehicle.
Right, CEO, just 1 second. There's a point of order, or no, point of intervention. Honorable Liz.
Mr. Chairman, thank you very much. I am a little concerned about the emphasis that's being placed on a dispute between the RAF and the AG and the technicalities involved there. I'm uncomfortable with us getting involved in that dispute and the technicalities and the reasons why. And it's obviously a very complicated dispute. And the fact that we've been informed about the dispute is absolutely essential. But I would request your consideration of whether this should be a topic for us to get embroiled in as well. And then, Mr. Chairman, obviously I have views about the publishing of the annual report, but that'll come later. Thank you.
All right. Yeah, I was waiting to see the explanation that was being provided because I share that similar outlook. Also to say that Parliament's own legal advice is that the sub judice rule is not applicable in this matter insofar as Parliament is concerned, and therefore we well within our mandate to proceed with the hearing. So that's the outlook, and it's precisely why the meeting was scheduled, because of that guidance that we had received. And also, I don't think that we are going to play out the court hearing here now to say that we are in dispute here, and then the AG to say this and that. So, all right. So I was hoping to hear what the introduction of the RAF was on the matter, and it's been framed in 3 categories. So maybe if we can hear that and engage in it, but we're not trying the matter of the dispute here. From our perspective, the audit report has been tabled. It's before Parliament. And we have not received any indication of its withdrawal. And that's why we are here. So, Honorable, yes, may I crave your indulgence momentarily and maybe ask RAF to proceed and hear what it is that they have to say, and then we'll take it from there.
Agreed. Thank you, Mr. Chairman.
Let's just hear them out momentarily, and then we'll make a determination. All right, RAF. RAF, you may proceed. Colleagues, are you still there?
Yes,
Oh.
we are here, Chair.
Can RAF proceed, please?
Yes, we are going to proceed, Chair. Ours was actually going to be to put matters into perspective as to why. And I think the Minister has already alluded to the fact that the annual reports of the RAF for the year 2020-2021 have not been tabled for the reasons of the dispute that exists. So I don't know how the Chair would like us to continue, but because what we wanted to indicate is the rationale of why the dispute is there and the nature of that dispute. I don't know if we are allowed to proceed on that basis, because that's the basis on which we wanted to come and present. And of course, in the process, what we also did was to say on issues that were there that are agreed, for instance, on issues around fruitless and wasteful expenditure and the regular expenditure, of course, we then provided that information to allow the space where that can be engaged with. But we want to be clear about the outcome and the determination of the Auditor General, so far as what they call an opinion, which we disagreed with and there is a dispute on. I don't know how the chair would like us to proceed.
Yeah, but I indicated that notwithstanding what Honorable Release had raised, that let's hear you out in terms of what it is that you have to say. And it was on that basis that I was calling you to come back to proceed, to hear you out.
Thank you, Chair.
The
Thank you.
substantive matter is that so that it's clear, our own legal guidance and advice is that the sub judice rule does not apply here. And secondly, before Parliament is an audit report by the AG. And so that is on the basis upon which this meeting was called. But I thought it's fair that we apply the alterum partem and hear you out in terms of what it is that is your thinking. And that is why I made the point earlier on a high level executive summary of the salient points, material points, and then the committee will make a determination there.
Thank you very much, Honorable Chair. Let me just take you through the presentation that we have had. We just give a brief background, the mandate of the NTT, and then we'll deal with the issues of the change in accounting policy. We'll, of course, deal with the chair dispute with the AGSA. Then we'll deal with the issues around the audit report of the 2020-2021 financial year, and then the legal proceedings, just what they are about. And then, of course, the irregular, fruitless, and wasteful expenditures. I said on the part that was agreed, the view was that we must then share it with yourselves for that to be engaged with. On the background, our entity is a social benefit entity formed in terms of the Road Accident Fund Act of 1996. And of course, we are a 3A schedule, PFMA entity. And of course, the main aim or the object of our existence, the payment of compensation in accordance with the Act for loss and damage wrongfully caused by driving of motor vehicles. Of course, then the background of audit outcomes, you would see that in 1920, we got a clean audit report. Before then, it was unqualified with material findings. And of course, before that, and I think 2016-17, we also had a clean audit. And out of the 6 years that we had 3 years of clean audit and 3 years of unqualified audit with material findings. And Chair, then let me take you to the change in accounting policy. I want to make a correction there, Chair. It is section 55(1)B and section 55(2)A instead of 1B of the PFMA empowers the accounting authority to prepare financial statements in accordance with the generally accepted accounting practice and to ensure that such statements fairly represent the state of affairs of the public entity, its business, its financial results, its performance against the predetermined objective and its financial position as at the end of the financial year concerned. I must emphasize, Chair, here the issue about the state of affairs of the public entity, its business, and that is where the dispute is in terms of this. And then one of the key deliverables that we were given and prioritized was the investigation of the escalating liability. When we started in the year 1920, the minister requested us to look into what was called the rough liability, which was actuarially based, which was escalating from the year 14-15. And the view was go and look at this liability and tell us why it's growing exponentially and find ways in which you must investigate this liability and the way in which we can deal with it. And of course, during the investigation, we discovered that the escalation liability was as a result of the accounting policy formulated using what is called IFRS 4, which is the accounting for insurance contracts. And I must emphasize, Chair, that RAF has no insurance contracts to talk about. And at the core of the accounting policy change was an obligating event, simply meaning when does RAF become liable for the loss or damage as a result of an accident. And the reality is that there was a dispute around that, once the accident occurs, the liability then ensues from the side of the road accident fund. This is the difference between us and the AG, in a sense that the most important aspect of our object is that in line the liability or this loss or damage is in accordance with the Act. It simply means that you apply the Act even after the accident. So the obligating event becomes a time at which RAF must assume liability, which means that one must firstly put in a claim in terms of Section 24. The liability must be assessed in terms of Section 17 of the RAF Act. And therefore, that's where the difference was. And of course, there was at that point, Chair, a misunderstanding of the letter that was issued by the accounting standard boards at the time to say people must use IFRS 4. But when the engagement came with the ASB, the reality was that the ASB then told us that that letter was just a guidance and at no point was it obligating us to change to IFRS 4, especially because we are a social benefit scheme. So the change in accounting policy is that RAF is in fact a social benefit scheme, and this you also see in Directive 1 of the Financial Services Board, Section 2.3.3 or paragraph 2.3.3, which talks about the assessing of the RAF's viability and sustainability. It simply says in assessing the viability and sustainability of the RAF in accordance, in its compliance with the provisions of the Short-Term Insurance Act identified under paragraph 2.2, consideration will be given to the status and nature of RAF as a public entity. And I think what is emphasis is that that is fundamentally a social security fund. So it must be understood in that context that the Insurance Act does not apply to RAF as the AG would like to have it, and that the Presidential Authority, who's our regulator, is very clear about that. So that's why GRAP 19 would not apply to RAF. Our business model is fairly like this, and you'd see it if you look at GRAP 19. It also tells you that the amount paid by people must be commensurate with the benefits that they get, which is not the case in case of RAF. The R2.18 that is paid is not commensurate to the benefits that are extended, and therefore RAF is a social benefit. I just add here that we then had consultations with ASB after that. The intention was to further investigate this accounting policy, and we then received these engagements also recorded in a letter that the ASB sent us, and this was in the year 2021. I think we met them in January, but the letter is of February, beginning of February, recording what was said there and the impact of the letter that they sent us on 14th. All they said is that the letter has no bearing on what we should do. In fact, the advice was that we must go to GRAP 3, paragraph 13, that talks about changes in accounting policies. When can you change the accounting policy? And they were clear that in that regard, it's either the entity shall change its accounting policy only if the change is required by the standard of GRAP, which was not the case. And secondly, the result in the financial statement provide reliable or more relevant information about the effect of the transactions, other events and conditions on the entity's financial position. And this is how this accounting policy was changed in terms of GRAP 3, paragraph 13B, which is the change was resulted in what we call reliable and more relevant information as it were. So that's how we changed this. At that point, we're using what we called IFRS 4. In our view, that did not fairly represent better than what was in the case. So there were changes that happened in the accounting field. In January 2020, the IPSAS B, which is the International Public Sector Accounting Standard Board, had issued a standard for social benefits. We must emphasize, Chair, that GRAP simply since 2008, when it was published, did not have and still does not have a standard for social benefits. Now, this consultations culminated in the process as expected to end, but I think what is important, Chair, is paragraph 8 of the same GRAP 3, which talks about what should happen where there's an absence of the standard. It says that in the absence of a standard of GRAP, that specifically applies to a transaction or an event or conditions. And I think we must emphasize this. It says management shall, which is peremptory, Chair, use its judgment in developing and applying an accounting policy that results in information that is relevant to the economic decision-making and needs of users, and reliable in that financial statement reflects fully the financial position, which is taking us to the provisions of section 55(2)(a). So that's what management did in that respect, and we dealt with this thing in line with those provisions of GRAP 3. Then, Chair, as I said, IPSAS B had already released this, but what is important as well is that GRAP 3 described the order of applications of accounting standards. That it must be firstly the standard of GRAP, followed by the IPSAS standard, which is IPSAS B, which is the International Public Sector Accounting Standard, and then it's only that IFRS then follows. Then it followed that in cases where we have got a standard coming from IPSAS B that deals with social benefits, the only logical explanation was that we move from GRAP, and GRAP does not have, and then we go to IPSAS. Once we find a standard in IPSAS B that deals with social benefits, you don't have to go any further. And in this regard, we found what is called IPSAS 42 on social benefit, issued in 2019 and was in application from, could be used from January 2020. And that's what we have done in that regard, Chair. Then the development of the accounting policy is done in line with paragraph 8 of the GRAP 3, which says management shall use its, and I think it's, paragraph 11. It says in making judgment described in paragraph 8, management may also consider the most recent pronouncement of other standard setting bodies and accept public and private sector practices to the extent, but only to the extent that it does not conflict with the association paragraph 10, which is just the interpretation of standards and the recognition criteria. For example, pronouncement of in descending order, International Public Sector Accounting Standard Board, including the conceptual framework of general purposes of accounting. So that's what has led us developing this accounting standard, because there simply exists no GRAP standard for social benefits that we could find, and social benefits are excluded in terms of the scope of GRAP 19, which says that the scope is applies an entity that prepares the present financial statements under the accrual basis of accounting shall apply this standard in accounting for provisions of contingent liability and contingent assets, except, which is an exclusion, those provisions of contingent arising from social benefits provided by an entity. So it means that GRAP 19 says we can't apply GRAP 19 and it's excluded from GRAP 19, and therefore social benefits, we have to go to a social benefit a standard that is published in terms of GRAP, and there's no such a standard. So we then had to deal with these things, but before we finalized, we then adopted the accounting, but we went also, this matter was also reviewed by an international accounting expert using an independent accounting firm to ensure that we had correctly applied IPSAS 42 and that we were not in conflict with any provision either in accounting. And after that, in May, we submitted our audit, our financials for audit by the AG last year in 2021. At all material times, Chair, the AG had been aware, and they are the ones that actually advised us to go and meet with the ASB at that point. So the dispute then resulted in this, and in that once we then issued this financials, a finding that saw the disagreement with the new accounting policy was then released by the AG on the 25th of June 2021. And we responded to the finding in line with what we have already said, how we adopted this policy, and why we think IFRS 4 does not properly account for the financials. The AGSA, however, concluded that the new accounting policy was not appropriate, and despite management explanation with the AG to extend the review, external review, this resulted in a dispute that was then referred to the Office of the Accountant General. And at that time, we also again went to the ASB. The ASB simply said to us that they don't deal with disputes between auditor and auditee because that was not in their mandate in terms of Chapter 11 of the PFMA. Then the matters for disagreement were then dealt with, and the AG just kept to their side. We then asked for the technical report from the AG, which they promised to give, which they never gave. And until at the time when in December, they decided that they are going to issue the audit, not their opinion, notwithstanding the fact that the dispute was not yet resolved. And that's where the legal aspect of things started to ensue, where the view was that the provisions of 55(2)A are clear. The standard, especially GRAP, specifically paragraph 8, is clear as to whose judgment should be used and who must develop the accounting policy. And also the provisions of section 3.3 of the PFMA that says in cases where there is a clash between, it just simply says, in the event of inconsistency between this act and any other legislation, this act shall prevail. It simply meant that the PFMA takes precedence and section 55(2)A takes precedence over any other, whether it's a Public Audit Act or any other act, then the PFMA prevails. And we had, led by the board, to adhere to the provisions of section 55(2)A. Consequently, Chair, we couldn't cite the undertakings that we make to the both the AG and the executive authority or parliament. The financials that were going to be presented to them fairly represent the rough financial position. So the audit report was then issued, and this has ensued as it were, Chair, and that's what has resulted in us not being able to issue our annual report and not going against the guidelines of the National Treasury on issuing of the annual report and signing the necessary documentation as provided for in terms of section 55(2)A and the Treasury regulations. So far as the legal proceedings are concerned, Chair, we then issued an urgent application saying that until such time that the dispute is resolved, the AG must be barred from releasing this, because then it creates it is not in line with the provisions of the PFMA in our view, and the AG refused. We went to court, and the court said they can proceed, but later on the court said that another court could find different meaning. When we appealed, we were granted leave to appeal the provision that says that AG can continue, and that is still ensuing. We also agreed, Chair, at that point with the AG to an expedited review, because, Chair, our view is that we must resolve this issue once and for all, and we couldn't resolve it through the dispute resolution mechanisms provided by the Office of the Accountant General. And we then agreed that then this is a judiciable dispute, and the AG agreed, and the AG even said that we must go for an expedited review. I must emphasize, Chair, that at this point, we have submitted our documents as early as early April, and the AG has not submitted, at the time of this presentation, had not submitted their answering affidavit, which was supposed to have been submitted by, I think, the 27th of May, if I'm not mistaken, and it has not been submitted until the end of August. In terms of the rules, which is the uniform rules of the High Court, Rule 26, they are actually ipso facto barred from putting any defense, because at that point, Chair, they have not adhered to the provisions of what a review application must entail, and they're out of time by more than 3 months. Thanks, Chair. I hope I have dealt with the issues of why we do not have this, and then we can take any questions if there are there. Thanks.
All right. So the matter is on appeal at the Supreme Court of Appeal, right?
Sorry, sir. So far as what we call the interdict application, but the matter of the review is still before the North Gauteng High Court, and as I say, the AG has not responded to our application so far as is concerned within the timelines, which was supposed to be on the 26th of May. If they had responded by then, we think that the matter would have been heard by now. But our understanding when we had a judicial management meeting somewhere around June was that the matter would actually be heard in October if they adhere to their timelines, which they still did not adhere. Thanks, Chair.
All right. Colleagues, I've sent through a letter from the AG to you. Because what I would really hate is for us to have to be seen to be adjudicating this matter without having had the opportunity of looking at all the material documentation. So I would have to trade with that caution. The fundamental issue, though, is that as things stand from our point of view, is that the audit report stands. I think that point must not be lost. The audit report is before Parliament stands. Right. AG, are you here? Any comments on your side? Without really going into the substantive material issues, because we are not adjudicating the matter here. So, yeah. All right, AG, over to you.
Good morning, Chair, and thank you for the opportunity. And maybe let me start by acknowledging and greeting the honorable members, the honorable minister, as well as members of the board of REF, as well as the executive management and all the other colleagues that are on the call. And Chair, maybe if I can start, I think it is indeed a matter of public record that we are sitting in a situation where, as we concluded the audit of RAF in the previous PFMA cycle, we did conclude it on a matter of dispute. In May, we did come to brief the committee around the audit outcomes, as well as the basis of those audit outcomes, and as well as the fact that this matter is indeed in front of the courts. As it stands, maybe to just put a bit of context into the matter, is that we have indeed, as the AGSA, filed our responding affidavits, and those were filed at the end of last week. So it is important that that point is also noted for the members that are currently on the call. Chair, I think maybe the one thing that one would really indicate at this point in time is that, given that these matters are in front of the courts, the areas where we do have differences with REF are really as it relates to the accounting policy. As the Auditor General, our stance is that the Accounting Standards Board is the regulatory authority that determines the accounting standards which auditees and public entities should comply with. Our responsibility as the Auditor General is that we then audit in terms of the accounting standards that have been set. To the extent that there has been a change in accounting policy and the new standards that have been used to develop that accounting policy, we do note that the Accounting Standards Board have not yet adopted those particular standards, and have given very specific guidance in terms of the accounting standards that would be applicable to entities such as RAF. And it is on that basis that we have then concluded our audit. And again, the main important factor in this whole process is that as we audit and we issue our audit opinion, ultimately the aim is to ensure that those financial statements then represent fairly the affairs of RAF. And we do that in accordance with the standards that have been, the guidance rather, that has been issued by the Accounting Standards Board. I think suffice to say that these matters are in front of the court, Chair. I think we wouldn't want to deliberate in this forum the merits in terms of the areas of dispute. I think those areas in due course will be ventilated in the courts, and we will ensure that from that process we do take note of the conclusions that the court will reach in that regard. I think what is ultimately important for us as the AG is the fact that as a constitutional entity, we do exist to make sure that we enable accountability and oversight. And it is important that that process be observed with the utmost care in terms of the audit opinions that we issue. And to that extent, Chair, I think it's important to then highlight to the committee and the members that the tabling of our report was really to ensure that we enable that accountability and oversight. And throughout this process, Chair, I think it's also important to indicate that we follow the accounting standards which guide our conduct. And we can assure this committee that in conducting this audit and any other audit in the public sector space, we have actually observed the requirements of the standards. And we believe that we have followed due process in terms of ensuring that this process was indeed fair. However, we do note that there might be a different view from the REF, and that's acknowledged. However, I think it is also a matter that will be ventilated through in the court process. Chair, maybe I can pause here at this point in time and allow the committee to continue with the matters of the day. And if there's any other input that is required from us as the Auditor General, to the extent that we can, we will then respond to those then accordingly. Thanks, Chair.
All right. As I said, we must not sort of, notwithstanding the fact that we are a separate arm of the state, but be seen to be now rushing ahead of a process that is already in motion in another arm. And so the merits and demerits of the dispute, whilst substantive, are ones that we have not considered, and we may prefer to have our own opinion on that. But I continue to reiterate, the audit report of the AG, as things stand right now, applies. And the sub judice rule, as I've pointed out, is not applicable on this matter. So we could proceed with it, and we'll consider and weigh our options accordingly on that one. There are quite a number of variables that would have to be considered and that we will consider. All right, I've got colleagues, please just take our side office as the meeting proceeds. I'm consulting as well on the side. Right, Babu Samuel, let's hand over to you.
Well, thank you very much, Honorable Chair. Good morning, colleagues, Minister. My view is encapsulated on the basis that the presentation by RAF gets deeper into a dispute, which might be a context that brings it to fore the areas of disagreements, and therefore delving on such when already the matter has been set for the courts to deal with, and probably it might be necessary to leave it at that instance, so that we don't circumvent the actual standing jurisdiction per se. The point which I thought would be of necessity if we are going to be delving on the areas that encapsulated in as far as the report of the Auditor General is concerned, would have been the elements that are of our own attention, putting aside the areas as we have been somewhat have advised similarly by the Auditor General, and deal with the areas that relate to the accountability in terms of the accounting practice, which are the practical aspects of failure or lapse in terms of their own actual accounting practice, whether during the current phase of our own analysis, have there been areas which we think are pertinent in terms of our own eye on the financial management, and therefore we can deal with those aspects. And such instances would require our physical meeting, which would be set for such interactions with the board per se on those matters, because currently we are denied that aspect of seeing the centrality of the board, because if our reliance is away from the accounting entity, it would somewhat seek to navigate away from the actual accounting practice that we set as a parliament, that the board should remain accountable in such instances. Yes, the CEO has highlighted these matters, but our view is that the board itself, its own voice, its own understanding, it's fair that we should be sitting and be listening to how the board outlook in as far as these matters are concerned. So I would be putting this that says, yes, we still have a lever to consider on the practical instances of accountability on lapses that relate to practices in the entity, and such practices would have been identified by the Auditor General in terms of their report, and would have to look into those aspects. The matter in question, which the CEO has spent time on, is a matter on dispute, and that matter which is on dispute is currently in the courts, and therefore would want to create a scenario which would want to, or not to circumvent the current jurisdiction in as far as that dispute is concerned. So my proposal is that one, let's have a meeting where would be a physical meeting where all of us will be sitting in one room. Two, that our focus would be focus that relates to those matters which are matters of concern in terms of the identified areas by the Auditor General for the accounting of this. Three, that the board be present fully in such a meeting, and therefore would want to keep the standard and practice of accountability in that essence. Thank you very much, Chair.
Right, that Honorable Hadebe, and then we'll take a decision. Minister, Ref, and colleagues, just hang 10 momentarily, and we will reach a logical conclusion on this matter. Honorable Hadebe.
Thank you, Honorable the Chair. And let me take the opportunity to welcome the Honorable Minister, Comrade Mbax, aka Vuta, the leadership of RAF and all other invited colleagues from the Auditor General and National Treasury, if they are present. Chair, I just want to, there are a lot of issues that one would want to ask as a clarity seeking question. And some of these questions, they relate to the process as outlined by the leadership or the management of RAF. But bulk of the question pertains to the audit outcome, which RAF did not say anything, even though there were general consensus or agreement as it relates to irregular expenditure, fruitless and wasteful expenditure. They did not say anything in relation to that. So they just stopped at the point where they outline the status of the court proceedings, meaning they do not take into cognizance or consideration issues as reflected by the Auditor General, as correctly stated in their presentation, that the audit inappropriately conclude on issues that are still ongoing. So one wouldn't want to engage in a half-baked process where we would want to find answers in relation to what we're going to be asking. But my concern, my primary concern, Chair, when we postpone until when, do we know how long will the court proceedings unfold and reach its final conclusion? What then happens next time if we set a date and the court processes are still ongoing? The proposal is that we do a physical meeting. In that physical meeting, if we opt for next month, if the court has not ruled, are we going to again postpone this case? I don't know the way forward, but indeed some of the issues, there are material differences and disagreement in terms of what Ralph is saying and the AG is saying. I would have loved a situation where I ask clarity seeking questions with a lot of questions of clarity pertaining to the entire process of amending the policy. Secondly, the understanding of the dispute resolution process and the outcome thereof. As per the Office of the Accountant General, I wanted to ask questions in relation to this, and also questions into allegation made on the process leading to what's the December 4th, where the Office of the Accountant General issued its feedback in support of the AG. I would have wanted to ask those questions. I would have wanted to ask questions in relation to the liability, questions in relation to the going concern, but I know the answer will be the matter is sub judice and won't get anywhere. But in closing, Chair, my main concern is till when are we going to postpone this meeting? If I can just get an understanding in that aspect, I would be happy, Chair, but I have a lot of clarity seeking questions as things stand. Thank you.
Okay, noted, Honorable Hattab. Honorable Van Minen.
Thank you very much, Chair. Please forgive me keeping my camera off, but I'm battling a nasty bout of flu at the moment. I agree actually with both my colleagues. I think that to proceed at this point is frankly a bit futile. I think there are some important issues here that need to be cleared up. However, I also agree that there is an inherent risk in a postponement. We don't know how long that will be. But I do think on balance that dealing with this matter, it would be better served once we have clarity on what is happening with court proceedings. And also, and I think this morning has been very indicative, this needs to be an in-person meeting. I can't see us really being able to be very thorough with this particular platform. So in essence, I wish I could offer a clear way forward, but I do actually agree in some ways with both of the previous speakers. Thanks.
All right, thank you very much. All right. Uncharted waters, fun. All right, colleagues, the matter is fundamentally very, very serious because in certain aspects, it sets precedents which we may not find desirable for oversight and which may delay oversight. And it has always just been my worry that our courts are overwhelmed and under-resourced, and the speed at which at times the wheels of justice or court processes moves is never in the collective interests of justice, oversight, and accountability, particularly in the space of public financial management. Because you see, we are being overtaken by events. You have got a audit report that is in dispute, and another one is coming out on top of that one, and the matter is still not resolved. So it does complicate the matter. But colleagues, I just wanted to make this suggestion. I've conferred with Mrs. Gabinde, and we can try and set our meeting in person on the 20th of September, and we will secure the parliamentary venue. I know that there is a difficulty with venues right now, but we can secure the 20th of September and then deal with the matters that are not in dispute. So we'll have to sift between the two, because I think that work must continue. And to then get an update on the manner and structure of the court processes, and for us to consider whether it would not be in the interests of Parliament to join this matter as an amicus curiae in the court, because I'm worried about the precedents that it sets into motion insofar as audit outcome management is concerned. It may open the floodgates rather, of disputes and negotiated audit outcomes, which places in a fundamental difficulty not just the Auditor General, but Parliament. So there is a level of clarity that is required insofar as audit outcome management is concerned, particularly because here we are saddled with a disclaimed audit outcome, which is the worst of the worst. And so, without casting any aspersions, disputes and or court processes must not become the default position of entities and departments to try and circumvent processing or accounting for a outcome, particularly one such as this one. This does not in any way presuppose an aspersion on the Road Accident Fund, but placing it as a general principle of caution in terms of what we must guard against. So I would really implore us to consider that one very carefully, so that we can be in a position to assert parliamentary authority and parliamentary oversight, specifically, but just generally in the space and scope of how these matters are actually dealt with, particularly a dispute. Because I just sense a situation that this may become a new normal. And unless we create the parameters now, it will become a runaway train for us. So I just wanted to make that proposal, colleagues, to say there are issues which we can deal with, but I think I'm proposing that we postpone to the 20th, deal with what we can, and also noting that the AG says they have filed papers last week already, and so that may fundamentally change the outlook which the RAF had when they came to this meeting insofar as the court processes are concerned. And in the interim, we'll make a determination of what we can and cannot deal with, and then we will take the matter forward in that sense. So that is just what I wanted to place before you colleagues as a way forward. Babu Somyo, I see your hand up, and Honorable Hatebe can then come in.
Well, thank you very much, Chair. I support your summary, and I think the date is quite suitable. We need to support it. And secondly, one would appreciate in the meeting the presence of the Office of the Accountant General, because it's what is key to this, that the finalization of any audit by the Auditor General ought to be based on the Accountant General's signature on the preferred standard at the time of the issuance and the finalization of such a audit. And therefore, Chair, I was just trying to, as well through my own creativity, trying to sort out the signed letter from the Office of the Auditor General in terms of the technical issues which have been raised, something which the AG affirms its own presence. And it would be good that through our team, we can source such a required information, because RAF says there is no such, and if indeed there is existence of such, must be availed to us by the Office of the Accountant General, which would confirm the actual signing off of any report they're on. Thank you very much, Chair.
Okay, thank you, Absomyo. Honorable Hadebe.
Thanks, Chair. In agreeing with Honorable Somio, it will also be in our best interest to have the Accounting Standard Board, as it was also mentioned in the presentation by Ralph, to be present. I need to stress, Chair, the Office of the Accountant General, because we were told, our understanding was that on the 4th of December, this matter was concluded, and the Accountant General ruled in favor of the EGSA. So it's important that those two offices are present, including Chair, National Treasury giving us not what we have received. That 2-slide presentation, Chair, leaves much to be desired. We need a better presentation in relation of this matter, because the Office of the Accountant General is located within the National Treasury. So we need a better presentation from them. Other matters, as contained by the report, will be dealt with, Chair, in our meeting physical. AG must be present as well, Chair. And it will be prudent if the AG can also have sight of the presentation by the RAF and respond to some of the issues. There are mention of having considered under threat of a disqualified audit, request for reports that were not submitted to date, so that we get an understanding why certain aspects from the AG side were not finished to Ralph. So we would want a meeting where all role players implicated in this matter will be present and would have been in a position of furnishing us with answers as it relates to presentation forwarded to Parliament. Thank you, Chair.
Babsomi, I see your hand. Is it a current hand or a historic hand?
It's an old hand, Chair.
Okay, all right. Okay, all right, all right. Minister, on the board and the executives of REF, I think that it is necessary to employ what I call a hambagahle approach on this matter, because of the complex variables at play. And I want to reiterate that we uphold the fact that the audit opinion report of the Auditor General holds insofar as Parliament is concerned and as tabled, and does provide sufficient basis for us to proceed. However, we do not want to prejudice the court processes, and in fact, they provide an opportunity not just for REF and the AG, but for Parliament as well, to structure audit outcome management for the country. So it's a necessary exercise which must be embarked upon, and we will consider all the material variables. So we will structure the meeting of the 20th, which will include but not be limited to the matters that can be dealt with and which answers should and must be provided with the necessary stakeholders and to reiterate that it will not be an adjudication on the merits and demerits of the dispute, which we fundamentally believe the courts have sufficient capacity to handle. So what we'll do is we will hold the matters in abeyance and suspend the meeting and reconvene on the 20th, and the details will be provided for that. And we hope that all the relevant and affected stakeholders will accept this as a necessary constructive effort to ensure that oversight and accountability continues uninterrupted, parallel to whatever processes may be in play, and we will hold due regard to those. And as I'm saying, we will consider the option of friends of the court on certain aspects of this matter as a means of ensuring that we do not have a runaway train of disputes and court actions on audit outcomes, and that they can be better handled in other areas. But as I'm saying, we will be proceeding on the basis that the audit report is before Parliament, and because of that, it requires the attention of Parliament, its complexities notwithstanding. So I hope that suffices, and we will be in communication accordingly. So I will hand over to you, Minister, if there are any comments that you would like to make, and then we will bring the matter to an end on that basis. Mphathiswa.
Chair, as indicated in my opening remarks, there is no question about government and its entities accounting to Parliament. And I wish to reiterate that we will be guided by the committee on the manner in which the committee intends to approach the rough audit report tabled by the AG. I also agree, Chair, with the committee that areas that are not in dispute be attended to. This is in line with the commitment we've made to ensure accountability to Parliament. Thank you very much and for steering the ship, and very briefly, I wish to pause there. Thank you, Chair.
Thank you very much, Minister. All right, so colleagues, I hope that that is in order. Let me take this opportunity to thank the Minister and the boards and the executives of REF AG, National Treasury, and SIU. As always, thank you very much for your presence. We will be in communication on this matter, and we will take it forward as already been explained. On that note, the meeting stands adjourned. Thank you very much.
Long live the chair.
Diabulela Mphathiswa.
Long live the chair.
Totswepo.